Well, thank you very much. Appreciate the chance to be here with all of you tonight, and appreciate everybody coming out tonight for tonight's program. And I'm particularly grateful to the United States Supreme Court for making it timely. Those calls usually don't work, but they work this time. I want to introduce you to a few things before we get started. To begin with, I am Mike Gerhardt. I have the honor of being the scholar in residence here at the National Constitution Center. That's one of my jobs. I'm also a constitutional law professor at the University of North Carolina at Chapel Hill, and frequent your airport a good deal, and your city as well, which I've fallen in love with. And before I go further, I just want to take care of a few housekeeping details. I certainly want to thank all the members of the National Constitution Center, and especially the leadership support of our 1787 Society donors who are joining us today. If you have any questions or like more information about the center, which includes invitations to exclusive exhibit openings, free museum admission, and discounted admission for town hall programs, please see Rebecca at the membership table in the Kirby lobby, where you can get more information. We will be taking a few questions from the audience tonight. Somebody will be circulating, taking your written questions, and then eventually they'll find their way to me. And of course, I need to ask you to silence your cell phones, if you don't mind. And most importantly, let me introduce our distinguished guests tonight. To begin with, Catherine Colbert, to my immediate left, is the Constance Hess Williams Director of the Athena Center for Leadership Studies, Professor of Leadership Studies and Professor of Professional Practice, Department of Political Science at Barnard College. She has been an extraordinary public interest attorney throughout her career, and among other things, she argued the landmark case of Planned Parenthood versus Casey before the United States Supreme Court, a case in which the court reaffirmed Roe versus Wade, and we will obviously be getting into more details about that soon. To her left is Mary Ziegler, Stearns Weaver Miller Professor at Florida State University College of Law, where she teaches family law, employment law, torts and reproduction, sexuality in the law, the author of numerous articles, as well as the recent book, After Roe, The Lost History of the Abortion Debate, which uses more than 100 oral history interviews and extensive archival research to challenge the conventional legal and historical account of social movement reactions to Roe versus Wade. And then to her left is Clark Forsythe. We love Clark too. Thank you for joining us, Clark. He is the acting president and senior counsel for Americans United for Life, and author of Abuse of Discretion, The Inside Story of Roe v., which has been favorably reviewed in the Wall Street Journal, Chicago Tribune, First Things, World Magazine, National Review, and other journals. Clark has done a lot of work as both a litigator and with not just state courts and federal courts, but also testifying before Congress and state legislatures. So we have an enormously distinguished, informed panel tonight. And I'm going to start with Mary to kind of bring us up to speed, if you don't mind, Mary. Give us a sense of not just what happened in Roe versus Wade, the decision there, and of course, eventually we get to Casey, which is going to set the stage for our discussion tonight.
Sure. So as many of you already know, Roe came in the middle of a long-standing conflict about whether abortion should be legal and accessible. So in 1973, the court struck down really the vast majority of abortion laws then on the books in the country, and in so doing created the trimester framework that the decision became famous for. In the first trimester, women were allowed to get abortion, or the state had very little latitude to regulate abortion. In the second trimester, the state was allowed to regulate only for reasons involving women's health, and only in the third trimester could the state act on its interest in protecting fetal life. Roe also concluded that the right to privacy, which the majority was sort of a little fuzzy about where this right to privacy was, but probably in the Due Process Clause of the 14th Amendment, was broad enough to reach a woman's decision to terminate her pregnancy. At the time, Justice Blackmun thought Roe wouldn't be controversial. As Clark can tell you, there was a clipping in his file of a Gallup poll suggesting that most Americans, roughly 70%, thought that the abortion decision should be between a woman and her doctor. So Justice Blackmun thought maybe this whole thing would go away, and as all of you know, we're still here, and he was wrong. So initially after Roe, the pro-life movement set out to create a constitutional amendment that would not only reverse Roe, but would recognize a right to life from conception and would effectively ban abortion across the country. And when it became clear that wouldn't work, the strategy that you see playing out in today's case, Whole Women's Health versus Hellerstedt, began to take shape as sort of incremental attack on Roe, chipping away at it piece by piece by introducing laws that the Supreme Court might uphold in state legislatures. And that strategy bore some fruit, most famously with the Hyde Amendment, which many of you know banned Medicaid funding for abortion. The court subsequently upheld that law in 1980. The court was a little less friendly to some of the other incremental attacks on Roe throughout the 1980s, but of course with Ronald Reagan and George H.W. Bush in office, the court's composition began to change, and so too did the court's attitude toward the right to privacy and toward Roe itself. So by 1986, in a case that both Kitty and Clark know a great deal about, Thornburg versus American College of Obstetricians and Gynecologists, the majority that had been supporting Roe was whittled down to 5-4, and it became clear that something was about to change soon. One of the possibilities in terms of things that might change was a version of the undue burden test, which was ultimately what the court adopted in 1992 in Casey. Casey involved one of the kind of multi-restriction abortion regulations that had become kind of common fare in litigation and an incremental strategy at the time. It involved things like an informed consent provision, a spousal notification provision, a parental involvement provision. And many believed, I think, particularly on the pro-choice side, that Casey was going to be the final nail in the coffin of Roe v. Wade. But what in fact happened was that the court did something that until today we didn't fully understand. It announced that the court was preserving, in a plurality opinion, what the court called the essential holding of Roe. That is to say that there was at least a liberty interest, maybe not a fundamental right, but a liberty interest protecting a woman's decision to terminate her pregnancy. But that the trimester framework in Roe didn't adequately balance the interests at stake on either side of the abortion issue. In particular, the plurality thought that Roe undervalued the state's interest in fetal life by recognizing it only in the third trimester. So instead, the court set forth the undue burden test, the one we see applied in Hellerstedt and in really every case since Casey itself. The undue burden test, as the court said, is sort of shorthand for the idea that a regulation has the purpose or effect of placing a substantial obstacle in front of a woman seeking to terminate her pregnancy. Now, what exactly does that mean? Casey itself wasn't that clear. We had a few clues. The court upheld all the restrictions before it but one, the spousal notification restriction. The court gave some sense that maybe that meant it was deferential. If after all the court could find an undue burden only once, then maybe legislatures had a lot more latitude to regulate abortion than we had previously thought. And that might have been the case or seemed to be the case in 2007 when the court evaluated the Federal Partial Birth Abortion Ban Act in Gonzalez versus Carhart and upheld it, suggesting that Congress had made findings about whether abortion was needed, or this particular method of abortion, dilation and extraction, was needed to protect women's health, and that in the face of scientific uncertainty, Congress got the tiebreaker, and the court would at least reject a facial challenge to the law. So going into today, there were a couple different interpretations of what the undue burden test could mean. On the one hand, Texas and some of the pro-life groups supporting it said that essentially all the undue burden test required was a reasonable purpose that set forth by the legislature and means reasonably related to it. That's a pretty easy standard to meet in constitutional law. Most of the time, even if legislatures can't figure out a reasonable reason they passed the law, courts can come up with one after the fact. On the other hand, it may be that the undue burden test required some sort of balancing, and this was what the majority in Hellerstedt ultimately held, a balancing between the benefits achieved by the law, either for women's health or for protecting fetal life, and the burdens the law placed on women seeking to access abortion. So the significance of Hellerstedt, I think, is pretty profound in the sense that it's the first real clear sign we have of what Casey is going to mean going forward. It's significant because it will result in many clinics in Texas staying open. It casts doubt on the constitutionality of a variety of similar laws in the states, but I think even more than that, it tells us more than anything since 1992 about the direction of abortion doctrine going forward.
Well, thank you. Thank you for that. We're going to record that so we can use it in my constitutional law class, bring people up to speed. But Clark, I know from the beginning you've written about a critique of Roe and some of the foundation of this doctrine that Mary's just sort of gone over for us. If you can, tell us what maybe some of the problems with Roe that you perceived and may have those, and the extent to which those problems persisted throughout other subsequent cases such as Casey.
Well, Mary has given an admirably succinct summary of it all, and I can't improve on that. But I would add a couple of points. First of all, you have to read Roe versus Wade and Doe versus Bolton together to understand our national abortion policy. And in Roe, the Supreme Court said, as Mary indicated, that the states could ostensibly prohibit abortion after viability. But then after viability, Doe versus Bolton, the separate decision, added this health exception and said that the states must allow abortion for any reason after fetal viability if the woman's health, which they defined as emotional well-being, was at stake. And it's the two decisions together, Roe and Doe, that established national policy as allowing abortion for any reason at any time. And so the two decisions together are sweeping decisions. They struck down virtually every abortion law in the country, and they isolated the U.S. as one of only 4 nations that allows abortion for any reason. One of 4 nations of 195 across the globe that allows abortion for any reason after fetal viability. You know, the court thought, as Mary indicated, the court thought it had settled the issue, but obviously 43 years later, the court hasn't settled the issue, and I would suggest that the court will never settle the issue because the courts can't do that, especially on this issue.
So, Catherine, you've sometimes, I think, more than been oftentimes referred to as a litigator who saved Roe in the Casey decision. In your argument in Casey, to help put today's event in perspective, tell us what this current case is about, how it fits into the narrative we've begun to construct here, and your own sense of the significance of today's decision.
Well, I think clearly today's decision was the most important abortion case since Casey. And it affected the largest number of women and let me just say, I think it's a remarkably strong opinion, put teeth into Casey that we always hoped would be there, in ways that we had always hoped the court would do. And I think for me, more than anything, if you went to I call the case Whole Women's Health because I always like to refer to the providers who are really at the heart of this issue and who do incredible work in the face of great antagonism from people across the country. And I think that the difference was who is on the court. And today, we have 3 women on the court, all of whom are very pro-choice, very willing to look at the facts of these statutes and how they affect real people. And that came through both at the oral argument and in this opinion. And I just want to say 3 things that I thought struck me the most about Whole Women's Health. The first is they took what we call the purpose prong of Casey, which was really just a couple of sentences. And they said a law is unconstitutional if it has either the purpose of prohibiting abortion or the purpose of interfering, placing a substantial obstacle in the path of a woman, or if it has that effect. So the first thing they did is they said the purpose prong really is real. It is something that courts need to look at. And that is contrary to a lot of lower court opinions that kind of just slid over that phraseology in the original Casey opinion. The second thing, and I think this is the most important thing, is the court said we're going to take a really detailed look at how these laws affect real people and how they cumulatively interact with each other. And it's not okay to say just go to another state, or it's not okay to say there's a health reason for doing this unless you can actually prove that there's a health reason. And the court really said very strongly that they're just not going to give deference to state legislative judgments about medical decision-making and medical facts when in fact they operate differently in the real world. And so they look closely at the medicine behind this, and frankly, there's really not a lot of dispute about the medicine. There's people on some side of the issue who oppose abortion, who don't do abortions, who talk about medicine. But for the most part, the medical community is very supportive of the pro-choice position and very much against these types of laws, whether it be ACOG, American College of Obstetricians and Gynecologists, American Medical Association, the big, large medical groups. And then the third thing that the court did, and I'm very pleased about this, is they said that in measuring whether a law is constitutional or not, we're going to look to the women who are actually affected. That is, in Casey, as many of you will remember, and I want to thank all of the people in this room who went through Casey with us, including my co-counsel Linda Wharton, who's here. In Casey, there was a provision that prohibited or required women to seek the notification of a spouse in order to get an abortion. And we went in and said, look, most women talk to their husbands about these circumstances, but there's a small minority of women, somewhere around 10% or less, who are in abusive relationships, who are separated from their husbands, who can't talk to them before they have an abortion. And as to that small number of women, this law is unconstitutional. And the court in Casey agreed with us that you look at that small number of people that the law actually affects. And today, again, they reaffirmed that holding in a very strong way. And I think that it makes clear to the lower courts, you can't just say this law is okay for 95% of the people. You have to look at the 5% who are impacted by it and are suffering from it to determine whether there's an undue burden.
Okay, well, thank you. And Clark, I want to come back to you with a kind of a two-part question, if you don't mind. First, remind us what the Texas law said, the law that just got struck down in today's case, but also what issues or problems do you see perhaps arising from the decision today?
Well, today's decision was a horribly tragic and unfortunate decision. Catherine's done a very nice job of explaining with what intricacy judges sit in judgment of abortion legislation coming out of the states. In fact, abortion is the only medical procedure in this country that is a constitutional right. There is no other medical procedure in this country that is a constitutional right. And what that means is that the courts sit in judgment on abortion legislation unlike any other type of legislation regulating medical procedures in the medical profession. In fact, the medical profession has been regulated as a profession going back to the 1600s in this country. But the Supreme Court, when it said that abortion is a constitutional right, established itself as the National Abortion Control Board. And it sits in, the court is responsible for every regulation in every clinic from coast to coast, and whether it survives or doesn't survive and how it scrutinizes it, unlike health and safety regulations for any other medical procedure in this country. And the court is incompetent to do that. The judges are incompetent to do that. They're as responsible for Kermit Gosnell as for the conditions in any other clinic anywhere in this country. And they can't exercise that competency. And the court supposedly thought it had settled this issue in Thornburg and then in Stenberg in 2000. Stenberg's decision by Justice Breyer was as strong an opinion, so-called, as this one here. And yet Stenberg was overturned, and I'm confident that this will also be overturned. Because these justices can't act in the self-appointed role that they have accepted for themselves since Roe versus Wade. And nothing really changes today. And this decision won't settle the issue any better than any other decision.
Mary, Catherine, you want maybe
Well, I just wanted
comment
to respond a second. It's not correct that abortion is the only medical procedure that is constitutionally protected. Remember, the right that's protected is the decision whether or not to have a baby or to have an abortion. That is, it's a reciprocal right around childbirth, not a right specifically for abortion. And second, and I think this is really important, the issue is, should legislatures or should courts make these judgments about what the medical underpinnings are? And in my view, courts who actually look at facts as opposed to politics are at least better. I'd prefer, the legislatures didn't mess in this area at all, but assuming they do, it seems to me, and the fact that there's a history of antagonism against exercising these rights and only this area, then I think courts are better equipped to do it than legislatures.
Well, Mary, even picking up on where Catherine left off, and I think it'll also pick up to some extent on what Clark said, you wrote the book After Roe, and maybe it's also after whole women's health. We need to think about, in a sense, what happens next. What are the issues? What can we foresee, if anything, that would arise from today's decision going forward?
Well, the irony in it, to me, in a way, was that when the undue burden idea was first being circulated, within the pro-life movement, there was an idea that the court was not yet ready to overrule Roe. Bob Destro and some of the people in Akron who were behind one of the big seminal 1980s cases thought, but the justices would listen to the facts. And so the undue burden test was going to be a vehicle for a fight about the facts. And now we've kind of come full circle where you see the pro-choice community rejoicing in a decision that essentially makes this fight about the facts. So it's quite clear going forward that there's a lot of room. Even Justice Alito's dissent, interestingly, did not focus on the interpretation of Casey that the majority offered. It focused on the majority's evaluation of the facts. So what you can imagine going forward is a lot of fairly extensive, elaborate, probably expensive trials about what the effect of these laws is going to be in the real world. Fights about, what does it take to protect women's health? This battle is already unfolding politically. The pro-life movement, since the 1960s, but with more emphasis recently, has argued that abortion actually negatively impacts women's health, psychologically and physically. That argument is going to come to the courts in a major way, now that the purpose prong has more teeth. When we're talking about what the real-world impact is going to be in terms of access, that's not going to just be something that you can kind of make logical inferences about anymore. We're going to see a lot of expert witnesses testifying as to that, a lot of trial evidence about that. And so I think Clark is right that this does the opposite of settle this conflict. It sort of tells us going forward that the undue burden test is going to have teeth, but that means that we're going to see case after case unfold in the courts in a really factually intensive, unpredictable way.
I would remind the audience, I certainly don't have to remind our panelists, that the court that decided the case today decided at 5-3. There were 8 justices. One justice, Justice Scalia, of course, died in February of this year. And Justice Scalia told us, Clark, that one of his concerns about not just Roe, Casey, the entire abortion doctrine, was that it placed the court in the center of this issue rather than leave it to the political process. So when we think about after Roe, and you said you think it'll be overruled, what would be the series of events that would have to unfold in order for that to occur? Wouldn't just be in courts, I think it would also have to be in the political process as well.
Well, the essential thing that would have to happen is that cases would continue through the courts, and state legislatures would continue to pass health and safety regulations, and they will. This isn't going to shut down that process. The court created a public health vacuum when it completely prohibited health and safety regulations in the first trimester when 90% are performed in Roe versus Wade. That was part of the decision in Roe versus Wade. The court completely prohibited health and safety regulations in the first trimester, and the court today basically reaffirmed that. But the public health vacuum continues, and the states are the only institution in our democracy that can fill that with positive legislation. And they will continue, no doubt about it. And there will continue to be test cases. And the justices can't settle the medical issues, they can't settle the scientific issues, they can't settle the political issues. They never have, they never will. And so this is just going to continue to be an engine of controversy. And we will have test cases sooner or later.
So Catherine, you know a thing or two about test cases, I guess, but I'm concerned as well with where you think things are headed after today's decision.
Well, let me say three things. First, and most importantly, presidents matter. Okay, presidents choose members of the Supreme Court, and this next election will determine the direction of the Supreme Court for the next decade or more. And so I am absolutely...
Quarter century.
Or the next century. I mean, this is really, really important. Who we elect to be our next president will determine this issue as a matter of law for a very long period of time. And frankly, having 5-3 versus 5-4 made the opinion stronger. If we could get 6-3, I think we will start to see fewer and fewer statutes introduced at the state level. So that's the first point. The second point is that who are our governors and who are members of state legislatures matter as well. And you know, I give Clark a lot of credit for his side of this issue because they learned how to ensure that state legislatures were anti-choice, and they did that through the reapportionment process that happens every 10 years. So I will say to you, the one thing that will change the dynamic of case after case and law after law that's aimed at inhibiting women's ability to obtain what I think of as a constitutionally protected medical procedure is to be able to control the majority of at least one house and or the governor's race in every state in 2020, okay, because that's the next reapportionment fight, and that is the key to ensuring that we don't have the next 10 or 15 years of this craziness. And lastly, I was going to say is political activity matters. It matters for how courts decide. It matters how legislatures decide. And so the kind of the malaise that we have found ourselves in, believing that this is inevitable, that legislatures are always going to pass bad bills and we just have to suffer through outrageous efforts by state legislatures inhibiting women's rights. The only way that's going to end is if people stand up and say, this is not okay anymore. And so, to me, what's really key, and the only thing that will change is get a great Supreme Court, elect a president who's pro-choice, change the reapportionment process by electing pro-choice legislatures and governors, and frankly, rise up as an electorate and say it's not okay to continue to pass efforts that inhibit women's ability to make the most fundamental decision in their lives, that is whether or not to become a parent.
So Clark, of course we all know Roe was 7-2, and yet it came within the vote of itself being overturned, Supreme Court overturning itself. And so I want to come back to your point about the case being overruled. I assume you would agree with Catherine that what happens in the political process matters, so the next election will matter. Do you see the fate of Casey or Roe coming up in this election? Do you see it, what's the path by which it gets, I'm wondering, again, what's the path that will be followed in order for the case to be challenged and overruled, in order for today's case to be weakened?
Well, I think Catherine summarized the political issues well, but I think the problems are even deeper than Catherine said, and the inertia that's going to keep this issue percolating despite reapportionment is going to continue. Today's case was about women's health and safety and whether the states can protect maternal health, but there is the complement to that issue, the state's interest in protecting the life of the unborn child. And since Roe versus Wade, approximately 40 states have passed fetal homicide laws. Approximately 38 states have passed wrongful death laws. All 50 states have a prenatal injury law. You are sitting here in a state, Pennsylvania, which has a fetal homicide law that works outside of the context of abortion, that treats the killing of an unborn child from conception as a homicide. And there are 25 states, half the states in this country, have a fetal homicide law that extends from conception. That is an enormous expression of public sentiment and where the public has been since Roe versus Wade. That's not going to be overturned by reapportionment. That's not going to be overturned by the Supreme Court. That's not going to be overturned by the next president. Those are deeply seated laws that express public sentiment in this country, and those deeply seated laws that have spread across this country since Roe versus Wade are not going away.
So Mary, to come back to the historian, I know as a historian you look to the past, not so much to the future, but of course I'm going to challenge you to
That's okay.
think about,
Nobody wants historians to talk about history. That's just sort of part of the job.
well, history repeats itself, so we're going to see if we can't figure out how it's going to repeat itself here. Do you think, based on what you've seen, what you've studied, your own work after Roe, we'll see more laws that purport to be about women's health, but the court said it wasn't really ultimately about that in this particular case today? And to what extent do you think states will essentially be able to, states have a role in either strengthening the decision today or weakening it?
I think absolutely states will continue passing regulations that are at least supposedly designed to protect women's health. I think that's inevitable. I think certainly today's decision makes it harder to do that. Today's decision, as Clark said, says nothing about states regulating to protect fetal life, and I think Casey itself makes that argument harder to make, because Casey, as I said earlier, after all, overruled part of Roe because Roe undervalued this interest in fetal life. So purely from a Supreme Court standpoint, the incentive structure is focus on the interest in fetal life. I think politically the incentive structure is very different. So in the late 80s and early 90s, leaders across the pro-life movement began recognizing that, as David Reardon, who popularized these arguments, said, if abortion doesn't help women, then why do we have abortion at all? So politically, the argument that abortion hurts women is crucially important, I think, to the pro-life cause. And so it's very hard for me to see that being abandoned politically. That's conceding way, way, way too much. And I don't think that today's decision in Whole Women's Health really closes the door on that either. The court was very specific about the record in this case. The fact, for example, that the legislature didn't make extensive findings about why this kind of regulation would protect women's health, or this specific law at any rate. So I think that challenges of that kind, even challenges about this specific kind of law in other states with different records, will continue to percolate through the court. But I do think it's a game changer in the sense that if your primary goal is winning in the Supreme Court as soon as possible, there's a clear, kind of clearer path when it comes to focusing on the state's interest in fetal life. And the purpose prong, as Catherine was saying, is easier to do with the state's interest in fetal life. It's easy to argue that any law that restricts access to abortion or reduces the rate of abortion protects fetal life. It's harder to argue that when you're talking about women's health. So I think that it creates additional obstacles to the women's health argument, but I think the political temptation is so strong that I don't expect that argument to go away anytime soon. I expect to see it made more forcefully and see both sides kind of engage the kinds of evidence that they've been bringing to bear politically in the courts.
So, Catherine, I want to come to you, and first your comment, then I have a question.
So let me remind everybody that it's not always been that we've seen the level of anti-abortion antagonism that we see today. Okay, in the days after Casey, from 1992 to about 1996, hardly any bills restricting abortion were introduced at the state level. And then after, again, reapportionment happened, we started to see more and more and more. Earlier, between 89 and 92, when legislatures thought their case might be able to get to the Supreme Court, there were 800 bills that were introduced. Today, we're seeing 1,000 bills that have been passed restricting abortion. So it's become a garden variety form of political expression that I think this court will hopefully slow down. And frankly, I think until they do so, I agree with you, it's full employment for lawyers, right? This is what this kind of...
That's the important thing.
Always has been.
Always has
Yeah,
been.
that's-
But I do think that when the Supreme Court says, we're not going to overturn Roe, that there is a constitutional right to abortion, strongly like they did today, We're going to start seeing a lot less of this. And we need to make sure that that happens, given the composition of those legislatures.
Well, the first justice to be nominated in the wake of Roe versus Wade was John Paul Stevens. In his confirmation hearings, there was a grand total of 0 questions about Roe versus Wade. Catherine, what about the next Supreme Court battle? We know it's already begun Supreme Court confirmation battle. We know it's already begun. After the death of Justice Scalia, there was a vacancy, of course, on the Supreme Court of the United States. President Obama has nominated Judge Merrick Garland of the U.S. Court of Appeals for the District of Columbia to take that seat. Right now, the Senate is not acting on that. Do you think today's decision is going to make it easier or harder for the next Supreme Court nomination if it's made by a Democratic president to get through?
Right. So let me just give you my view on what's going to happen with Garland. I'm just going to throw this out. It may not be true, and don't hold it against me if I'm wrong. But I think what will happen is if Hillary Clinton is elected president, Garland will be confirmed between the time of the election and the time she takes office. Because the Senate, at least the Republicans in the Senate, will not want to get somebody who they consider to be worse than Garland. Okay? And of course, Hillary Clinton will appoint somebody who is really good on these issues. There's no doubt about that in my mind. She's been an advocate in this area forever. The second piece, though, is I think that the history of the nomination process, and we've seen this since Bork, is that abortion often gets asked, it doesn't often get answered. So that you often have questions given to the nominee, what do you think about this? And they, as a matter of routine, say, that's an issue that might be before the Supreme Court when I'm a justice, and therefore I'm not going to give you any guidance. The only person who actually gave us any guidance was Clarence Thomas, who said he'd never read Roe versus Wade. So that was a pretty good example of somebody who just wasn't telling the truth. So, we didn't expect that he would be supportive in this.
So, Clark, with the next Supreme Court confirmation battle, do you think there'll be discussions about today's case or about abortion rights? Is Catherine right that perhaps we don't expect the nominee, whoever he or she is, to answer the question? To what extent do you think that the Senate itself, I'm asking a lot of questions here, is actually resisting the nomination right now in part because of a concern about what it means for this whole area?
Well, question I would ask Catherine is, why do you got Justice Kennedy? Why do you need Merrick Garland? I mean, one of the stunning impacts or outcomes of today's decision is you've got a 5-justice pro-abortion majority on the court. They've been asking for that since 2005, time after time. We need a pro-abortion majority on the court. Well, they got it, so why do you need Merrick Garland?
Well, 6 is always better than 5.
And I feel compelled to say, and there are other cases too that could benefit, perhaps.
Mike, as you know, Justice Stevens' confirmations hearings were the last ones at which abortion wasn't raised. There have been lots written on how the abortion distortion doctrine of the Supreme Court has distorted judicial nomination hearings. There is an undue focus on abortion in judicial nomination hearings, incredibly undue focus. Justices, judicial nominees aren't asked about many other areas of American law that they should talk about and discuss and express and reflect some kind of expertise on, because the abortion issue has sucked the air out of the room since the 1970s. It is another element, reflection of the terrible impact of Roe versus Wade on American law and American jurisprudence and on judicial nominations. And that's not going away.
I've got a lot of questions here, and I'm not that fast a reader. But let me, I feel that this next question may be more for Catherine, if it's okay. It comes from the audience. It seems that states can use budgets to explain and excuse cutting funding to abortion clinics. How can this be exposed as an undue burden versus simple economics?
Well, let's distinguish between laws like that in Texas, which were actually substantively inhibiting women's ability to get abortions in a medical sense from the cutoff of funding for Planned Parenthood, primarily around contraception, which is going on at the state level. So the biggest area here is funding for contraceptive and essentially ways to prevent abortion. So to me, that's the biggest travesty here, because of course, if you want to reduce the number of abortions, which I think we actually can agree on is an admirable goal, right? If you want to reduce unintended pregnancy, the most important thing to do is to provide contraceptive and family planning services. And so cutting funding for those is really a problem. And I think the problem has been that there was a case in the Supreme Court called Harris versus McRae, which basically said when you cut off funding for something, it doesn't really, it gives people a choice whether to get funding or not, but it doesn't inhibit the underlying right. So the cutoff of Medicaid funding for abortion in federal law was not unconstitutional because the court basically said states could fund it on their own, the federal government could provide it or not provide it, but that isn't what is making it difficult for poor women to get abortions or to get contraception or abortion. What's really going on is she's just poor. So they said that's not an inhibition. To me, that's a travesty of our law. It really doesn't recognize what real women, particularly low-income women and young women, face when they have no insurance coverage or they have no Medicaid coverage. But the Supreme Court has said otherwise, and that's why I need my 6-3, because I think that would give us an opportunity to reverse that horrible decision.
So I'm going to jump to Clark here because I've gotten this question from several audience members, so that's my signal I should ask it. And it's asked in somewhat different ways, but I'll ask it in a more direct fashion as one audience member has phrased it. So Clark, what makes you think that you have the right to make decisions for women given the fact that you're a male? Let me rephrase it as well. Most of the legislatures that regulate in this area are dominated by males. So does that skew the outcome?
I think, Mike, your demographics are really off.
It's the
Because
question
in the
Yeah.
past couple of months, we've seen Congresswoman Marsha Blackburn chair hearings into Planned Parenthood's practice of fetal tissue harvesting and sale. We've seen Governor Mary Fallin in Oklahoma sign into law a regulation on abortion that was sponsored by a woman legislator. We've seen Governor Nikki Haley in South Carolina sign a 20-week limit that was supported by women legislators. The fact of the matter is that the percentage of state legislators who are women has changed dramatically since Roe versus Wade. And many are champions in their states for pro-life legislation. And of course, aside from the ad hominem nature of that question, the fact is that none of us would want that same ad hominem attack made on us if we supported justice causes. You know, it means, you know, if you haven't personally experienced injustice, then you can't talk about it. If you haven't personally experienced injustice, then you really should have no position on it. And that, of course, would diminish American democracy and our ability to gather together as citizens to protest injustices that maybe we've never personally experienced. And I would also say that as a husband of 35 years and a father of 5 daughters, I am staunchly in favor of raising independent, strong-minded women. And unfortunately, the abortion right is a you can't do it message rather than a you can do it message. And that's why it's so profoundly contrary to human dignity.
Well, thank you for that. Mary, I want to take you back into history a little bit. You should feel free to clap.
I feel like there's some clapping.
Freedom of expression is very important here at the National Constitution Center. Also, freedom of religion is important too. And I want to so this question, Mary, is asking about, it says, anti-abortion laws are pressing, or perhaps maybe based on religious views. To what extent would you agree or disagree with that? And then the person also asked, do you think that kind of thing, which would be laws based on religious views, be allowed in this context?
Sure. So I think that the premise of anti-abortion laws really varies because the pro-life movement, like any social movement in America, is a big tent, right? So Clark is right that there are a lot of pro-life women who want to make these decisions. And I think that with respect to religion, certainly the origins of the pro-life movement were in the Catholic Church, if you go back to the 30s and 40s when the movement started. But there are many people who joined the pro-life movement, including a lot of the kind of key leaders in the 70s and beyond, who had what looked more like secular moral views about why abortion was wrong. So it's very hard to generalize. The court in Harris versus McRae, the case that Catherine talked about, kind of closed the door on a lot of these religion-based claims because after all, there's constitutional arguments you could make on this basis, right? Either that the state was adopting a sectarian view of fetal life or of the abortion issue writ large, and that would violate the Establishment Clause, which says you can't establish a religion or take sides in religious conflict. There were also arguments that the state was interfering with the free exercise of religion, because there are religious Americans and believers who think that under certain circumstances their conscience compels them to terminate pregnancies rather than continue them to term. The court pretty firmly rejected both of those arguments in McRae in 1980. So reversing that case would make a big difference not only to the funding issue, which of course is probably the single biggest access issue on the table, but also to these kinds of religion-based claims. So you can make them politically, but they're kind of a non-starter in the Supreme Court unless Harris versus McRae goes out the door.
Catherine, I'm going to come to you the next question, although Clark, you may have something to add to it, because it's about Justice Thomas's dissent. And the question that's asked from the audience is, please comment on Justice Thomas's dissent regarding the standing issue. If you don't mind, maybe set that issue up for us and talk about his dissent.
So, actually, I read Justice Thomas's dissent this afternoon and I went, oh my God. Because I thought the two pieces of that dissent were so far out beyond the mainstream of American law that it really surprised me. So the first thing he said was that women, these cases are Roe versus Wade or Doe versus Bolton, because they are anonymous women who don't want to reveal the fact that they're pregnant, who are plaintiffs in the case, or there are clinics and doctors who represent their own clients and their own patients. And that standing, what's called third-party standing, the ability of somebody to represent the interests of others, in this instance has always been recognized because for two reasons. One is most women who are pregnant and in need of an abortion do not want to bring a federal lawsuit about it. Why? Because it reveals their identity to the rest of America at a time when they're facing an unintended pregnancy. They may be too young, they may be married, and don't want their husbands to know. There's any number of reasons why they want privacy to surround that decision. And what Justice Thomas basically said was, no, we think the woman has to bring the case in her own name, and all of the anonymity and the ability of third parties to represent their interests should not be recognized. In practical reality, what that means is there would be no abortion litigation because women would not bring those cases. So it's a backhanded way of really being outside, what I think of it outside the mainstream. The second thing he said, and again, this is for the lawyers in the room, he basically said that he's disturbed by the fact that there is what is called intermediate scrutiny. That for a range of constitutional rights, whether it be abortion or whether it be the right to marry or whether it be immigration or adoption, all kinds of constitutional rights that fall, gender basically, that falls under what we think of as an intermediate level of scrutiny. He doesn't think that's right. He thinks there either should be strict scrutiny or no scrutiny at all. And I think, while I'm not clear from his opinion what he would give strict scrutiny to, I'm pretty certain that it would be a very limited number of rights. Perhaps the Second Amendment, perhaps racial injustice, and that's probably about it. But women who suffer discrimination, women who can't make decisions about reproduction, immigrants who can't assert their interests, criminal defendants who all get a range of middle-level scrutiny, he would say, nah, I'm not going to recognize those interests.
So Clark, I want you to talk about the dissent if you want to. Is there any other part of either Justice Thomas's dissent or Justice Alito's dissent you think should sort of be emphasized today, and Mary too?
Well, what Catherine referred to as third party standing is another aspect of the abortion distortion factor of the Supreme Court's rule in this area. Because just think about whether you would want a doctor to go into court and say that you don't need health and safety regulations. Just let me self-regulate. Would you want your doctor, any doctor that you might have, to go into court and sweep away health and safety regulations saying, my patient doesn't need them, I can take care of everything? And that's the distortion that the Supreme Court read into its abortion doctrine in 1975. Unlike any other, virtually any other area of American medicine, providers can go into court for their patients and say, they don't need regulations, they don't need any health and safety regulations, we don't need any standards, I'll take care of it. You wouldn't want your doctor to be able to do that. And Justice Thomas today didn't say anything about anonymity. He said that doctrine is spurious and it's an aberration in our law, and we should admit it as such and apply normal rules for medical cases. The other aspect of his dissent was what some scholars have said, medium rare scrutiny, that the justices create this level of scrutiny and this level of scrutiny and this level of scrutiny and this level of scrutiny, depending on whether they politically favor the parties in a particular case. So they apply this level for the parties they favor and this level for the parties they don't favor, and it's really all a bunch of politics. And that there should be more objectivity in the standards that the justices apply, and he was pointing that out today.
I think the striking thing about Justice Thomas's dissent to me was that it was just Justice Thomas's dissent. So Justice Alito's dissent got other justices to join. And interestingly, Justice Thomas was really the only one who engaged the majority on what does the undue burden test mean. So Justice Breyer's majority said, okay, we have to have this balancing of benefit and burden. Justice Thomas said, no, we don't, that isn't true. Justice Breyer said, we're not going to be as deferential to Congress and state legislatures as you may have thought after reading Carhart. Justice Thomas said that isn't what Casey intended. So a lot of the arguments that Texas was pressing really were only picked up on by Justice Thomas. Justice Alito seemed pretty content to say, okay, there's going to be this huge fight about the facts, and you, Justice Breyer, got the facts wrong. You can't make sense of the facts the way the majority did. That just doesn't make sense. I think that tells you a lot about where we're going. If the three who are the kind of most likely to be allies of the anti-abortion movement going forward, the majority of those folks are okay with this being a fight about the facts, which I was really kind of shocked by going in, because if you read a lot of the briefs in the lead up to Whole Women's Health, there was a lot of emphasis on saying essentially the undue burden test equals rational basis, equals no scrutiny at all. And Alito didn't really fight that a lot. I mean, there's sort of hints that he thought that might be right, but there's no kind of bold proclamation that that's wrong, other than in Thomas's opinion. And I think the fact that Thomas found himself alone in a lot of that is just as telling as what he said.
But I would just add that, as you all know, dissenters on the Supreme Court justices and great dissents throughout our history have been by justices who wanted to go it alone.
Oh, yeah.
And they wanted soaring language and to write more sweeping statements than other justices would join. And it's possible even that Justice Thomas didn't want any other justices to join his dissent, because he could say things that the other justices wouldn't join. So
the one thing I would add on this is if I was Clark, I'd be really missing Justice Scalia these days. If I was, representing the other side on this, I'd say, the loss of Justice Scalia is significant. And that's really, if you read the dissents here, you get that feeling. There was
I've-
no bite.
I've
to
never said
any
I
of
didn't
those.
miss Justice Scalia.
I kind of wish that Justice Scalia could have rewritten Justice Thomas's opinion with more like jiggery pokery and applesauce.
Something
and
tells me that Justice Scalia would have written his own dissent.
Oh, yeah, that's true.
It would have been impassioned, and it would have been quoted a great deal tonight. But I also, Catherine, want to ask a question that's come from the audience, which I think picks up on one of the aspects of the court's sort of doctrine, its legal framework. So since the Roe versus Wade decision, our medical sophistication has become such that we're able to call viability earlier and earlier in a pregnancy. So what happens to the decision when we're able to sustain life at 1 day or immediately after?
You know, I will address that very seriously. And what we know is it's slightly earlier, but really what's happened is there's a greater number of survival rate at the same level. But medically, really we are limited with being able to have more fetuses survive by lung development. And no technology in the world is going to solve that problem. But let's remember that abortion is, for the most part in America, performed in the first trimester. Slightly, about 90% of all abortions are performed in the first 3 months of pregnancy. More would be if there weren't so many impediments and there was more money available for people in need of these procedures. Because what happens if you're a low-income woman is you don't have enough money, so you wait, and then by the time you wait, you still don't have enough money because the price keeps going up the longer it goes. So the reality is most abortions are performed in the first trimester, and if it was up to me, more and more would be. Because, of course, that's what's best for women. It's safest, it's what they want, and, you know, again, removing impediments will make that better. So I think that this whole notion of survival is really only affecting probably 0.5% of all women seeking abortions who have abortions post the period of viability. So even if viability moves a week earlier, which is about as earlier as it could get, you're still talking about 1% of all abortions. The reality is that our public policy needs to make reproductive health care from contraception through abortion accessible, safe, and away from what you're concerned about, the state legislatures trying to regulate in an area which is really punitive. What we need is good health care. We need accessible health care for women, and that, to me, is going to solve that problem.
Clark, do you see this as a weakness, how viability can be pushed back farther and farther? Would you agree with Catherine that there's a point at which it can't be pushed back?
Medically speaking, I don't see viability as a huge future issue about fetal survival. I wouldn't be so bold as Catherine as to say no technology is going to make that change, because we're always surprised. The problem with the viability rule in Roe versus Wade is worse than that. It was completely arbitrary. And in my book, Abuse of Discretion, The Inside Story of Roe versus Wade, I go through the personal papers of the justices and point out note by note, letter by letter, memo by memo, just how arbitrary was the viability rule. It was completely cooked up out of nothing. No medical organizations urged the court to adopt a viability rule. The lawyers didn't even talk about the V word of viability in 4 hours of oral argument. It was completely cooked up. And one of the problems with it is that it's rickety in the sense that it actually sweeps the abortion right into late-term abortions, fostering late-term abortions more than there otherwise would be, because no woman, because viability is determined by medical statistics. It's not something a woman feels or notices day by day, because it's based on medical statistics. And so a woman doesn't know that she's coming to the point of viability unless she gets some medical examination. And yet it gives women the liberty to have abortions beyond the point when abortion is somewhat safer. I mean, the maternal mortality rate after 20 weeks goes through the roof. Why should the Supreme Court encourage women to wait until viability or beyond? A 20-week limit would be protective of women's health. It would be much more clear and specific, and it would alert women, hey, you're getting very late in pregnancy, you need to make a decision. The viability rule is terrible in that
Catherine,
regard.
I want you to respond to that. Also, if you can, address this last question I'm going to ask for the audience, even though our time is expiring, but I want to get to these. So I want you to both respond to that, but also I have a question from the audience about what about the small number of women who are under duress from a spouse or boyfriend to have an unwanted abortion? Shouldn't the courts be more concerned about protecting the rights of these women?
Absolutely. And in fact, in Casey, they were. As you'll recall, from those of you in Pennsylvania who remember the history here, the first law that the legislature passed was requiring the consent of a husband. That Governor Thornburgh vetoed, and then the second version was requiring notice to the husband. And even the most conservative court in the Third Circuit found that unconstitutional, and the Supreme Court did as well in Casey. So absolutely, the rights of women who are in abusive relationships need to be protected. And I think what hasn't been talked about at all tonight is the notion of how gender plays out in all of these things. And to me, that's really important. So, Clark makes this elaborate argument saying, well, the medical board is being usurped by the courts. But the reality is there's no other procedure in the world that gets this kind of political attack, where people are being, doctors are being killed or being, protested against, or where women are being forced to run the gauntlet of protesters in order to have an abortion. And frankly, if this was the case on any medical procedure affecting men only, like the availability of Viagra, we would see something very different at the legislative level. So I really want to remind us that gender plays a huge role in attacks against women around abortion. And in some ways, the irony is, of course, this is one of the safest medical procedures that's ever done. It is more dangerous to have a whole range of outpatient surgical procedures from colonoscopies on up than it is to have an abortion. So this really isn't about safety. It isn't about medical care. It's about attacks on women and attacks on women making decisions about whether or not to have children. And we need to remember that and make sure that that is no longer acceptable at all levels of our
Clark, I'll give you a brief response, and I want to come to... if you want it, I'll give you a brief response, and I want to come to Mary for the final word.
I don't know if I can briefly respond, but the fact of the matter is that the court created a public health vacuum, and we have no reliable data in this country about abortion, unless it's cherry-picked from some small study done in some clinic. The fact of the matter is we have no national law that requires the reporting of abortion numbers or complications or deaths. We have two sources of national data, and from the Centers for Disease Control and Prevention and to the Alan Guttmacher Institute, and reporting to both is entirely voluntary. The number that you think is reported by the press and the CDC annually about the annual number of abortions, that's not real data. It's just an estimate. California, which historically has had 1/3 of the abortions in the country, hasn't reported data for years. How do we know how many abortions, even just the number of abortions in this country, if the state with 1/3 of the abortions doesn't report its data? So because we have no reliable data, and we haven't since Roe versus Wade, we don't know the number of complications or the rate.
It was Ronald Reagan who cut off data collection at the national level. We had very, very good CDC statistics on abortion from 1973 until Ronald Reagan became president, and Ed Meese went to Congress and said, we need to, let's take this out. And he eliminated the abortion surveillance unit of the CDC. And I agree with you, we need data. And the only reason we don't have it is people on your side of the issue eliminated
The abortion surveillance unit reports data year after year after year. They always have. It's just.
But now it's voluntary, up until
There was
Ronald
no
Reagan.
national law before Ronald Reagan that was repealed by Ronald Reagan.
Yeah, there was the abortion surveillance unit of the CDC.
It wasn't based on a federal law compelling data.
It was,
let me
yeah,
come
I
to
mean,
Mary.
we could fight about this, but I actually agree with you.
We bring a little bit of the world into this room, but let me come to Mary for the final word, if I may. And again, it's not a fair question to ask anybody, but you're the final seed. So what do you foresee, if anything, will settle this? The 2016 election?
I'm of the opinion that nothing will settle this. I think that
What was that?
nothing will settle this. I think just because the people on either side of this issue, I think, hold very profound, very sincere beliefs that date back, in spite of what Clark says, well before Roe, right? I mean, the beliefs of the pro-life movement fortunately run deeper than Roe is a crappy decision. That would not motivate people as much as really deep beliefs about the life of the unborn child, and really deep beliefs about women, too. I mean, I think that pro-life women in particular have particular attitudes about what abortion means to women that run really deep too. And I don't think the court can resolve those issues. I don't think politicians can resolve those issues. The only thing that would come closer to resolving this issue would be the kinds of solution Catherine described earlier, like getting together to do things to make women feel that abortion's less necessary, like better health care, like some of the kinds of things the pro-life movement still is willing to work with the pro-choice movement on, like better laws against pregnancy discrimination, the pressures that put some women in the position of terminating pregnancies they might want to bring to term. I don't think that would really resolve this issue either, but it might relieve some of the pressure. So I think it's just, this will be with us way longer than I'll be around to talk about it.
Well, I appreciate your talking to us, and I do want to thank our panelists tonight. Our conversation will not end tonight. It will extend. One of the things that is most wonderful about the National Constitution Center, and there are many wonderful things, is that it's dedicated to civil discourse, and it's dedicated to educating us about these very difficult, complex, enduring constitutional issues. And I want you to join me in thanking our wonderful guests for help.
Good job. Thanks.